The state of New Jersey has some of the strongest protections for whistleblowers in the country, and most employees don't know their rights. We're going to talk about CEPA today and how it really protects you. Anton from Kaminsky Law. Anton, explain what CEPA is and how this law protects whistleblowers.
So New Jersey's got this law called the Conscientious Employee Protection Act. And you're 100% right. I don't know if it's the strongest law in the country, but it's certainly one of the strongest laws in the country. And there's a couple of reasons for it. It really gives employees protection from doing anything that they think is illegal, anything that they think is fraudulent to some extent. It gives them a lot of protections if they report things, even if their, reports aren't super official.
Well, let's really quick. We're talking about whistleblowers. I want to define a whistleblower here because I think we all have this sort of idea of someone going, working within the federal government, the CIA, but any employee could be a whistleblower on an organization that is doing anything illegal, fraud. What are some of the things that you run into? Because I think we normally think about whistleblowers as, some of the worst sort of crimes, right? Violence, assault, those types of things, and conspiracy, that sort of thing. It doesn't necessarily need to be that egregious, right, to be illegal and to be cause for a claim.
So let's distinguish between different states for a second,
okay.
Right? So typically, the whistleblower law needs something, and again, I'm just talking in generality, so it's specific for every state, it's specific for federal, but generally speaking, in order for you to be a whistleblower, as that term's commonly understood, you have to be able to go and make a report, like usually a written report, oral report. We'll talk about making a verbal report later, but you usually have to make a written report to some governmental body, right? Before you're considered a whistleblower, right? For instance, if I work at a business that I think is, defrauding Medicare, right? In Pennsylvania, for instance, before I'm considered a whistleblower, I actually have to go and file a report.
So I can't just go on Facebook and go, hey, look at what these guys are doing. I'm a whistleblower now.
No. And I don't think in New Jersey you could either.
Okay.
Right. But in the distinction between states like Pennsylvania, for instance, and a state like New Jersey is in Pennsylvania, if you report what you think is unlawful activity or illegal activity to your supervisor, you don't necessarily get protections. Sometimes, some cases, you would get protections. I don't want to get too far into the nuance, but you don't necessarily get the protections if you report things to your supervisor in Pennsylvania.
In Pennsylvania, okay.
If in New Jersey, how that's different is there's so many, you can drive a truck through the definition of what a report constitutes, okay? And so you can refuse to participate in unlawful conduct, right? So you could tell your boss, I'm not doing that. I think that's illegal. That counts. You've reported,
okay.
Right? You can go to your immediate supervisor, not the CEO of the company. This is my manager. You tell the manager, hey, I think what we're doing is illegal. You've reported. You can go and, I advise people not to make any sort of verbal reports because then it's he said, she said. But, you sent an email, you sent a text message and said, I'm not doing this to your supervisor or to a manager. You've made a report for the purposes of New Jersey's CEPA Act. It's very, very all-encompassing. And the refuse to participate thing is such a big hook that doesn't really exist in a lot. I mean, I don't know where it exists or doesn't exist.
Right.
It definitely doesn't exist in Pennsylvania. Okay.
So when you say refuse to, I have to at least tell you, my supervisor, somebody, that I'm refusing to do this, or if I just refuse to do it, is that why
there's best practices, right?
Right?
Let's talk about best practices, because at the end of the day, if you're going to sue somebody for CEPA, and we'll talk about how you can do that and where you can do that, you're going to have to prove your case, right? You're going to have to prove that you made a report. So the best practice is that you still make some sort of noise,
right?
Right. And if you don't make noise and you just say, I'm quitting, that, probably won't count.
That's not enough.
Right. That's not enough.
So what does it look like? I mean, it's not something I've even considered. And you think about a whistleblower's role and responsibility in this, or, we've always talked about damages, right? The damages and the financial. So aspect of things, when a whistleblower comes forward, are they the ones conducting the lawsuit? And is there potential damages that they're like when you're describing the situation of the claim, right? When we get to that point, and now you're looking at, I imagine, let's go through the scenario. Hey, I'm a whistleblower. I approach you. I go, hey, I came forward. Your first question is probably going to be, what kind of notice did you give? How did you do it? Right. You say, here's a text message I sent to my boss, who's, a manager. And I told them that I think this is illegal and I don't want to do this. Right. So those are those two criteria you talked about earlier. Am I going to court and are you representing me and I'm potentially winning a case against my old business? Is this just getting passed to the courts and I'm just a nice person, but probably don't have a job anymore? Like, what does that look like?
Great question. So CEPA typically protects retaliation against whistleblowers. Okay. So typically you just having reported something that was unlawful isn't, okay, fine. You reported it. If they fixed it and didn't do anything wrong to you, we're good. You could keep moving on with your life.
And you're not suing them now.
You're not suing them. That wouldn't
like
be
that.
A claim.
Okay.
So what typically winds up happening, and I've seen, a variety of a range of circumstances that happens, is as soon as an employee reports something like that, what winds up happening is they either get completely shut out of whatever they were doing, right? They lose their responsibilities, right? It's like in the movies where they shove the cop in the basement, right?
Right.
They either completely lose their responsibilities, they get a demotion, right? Or they get fired altogether.
Okay.
And so, I think it makes sense to kind of go through and say kind of what the elements of a CEPA claim are.
Yep.
And so, and kind of like what you need to establish to make a CEPA claim.
For sure.
And so the elements of a CEPA claim is number one, you reasonably believe, and we'll talk about this reasonably believe piece also because it's important, but you reasonably believe that what they're doing is unlawful. And again, unlawful could take a range of things. You then perform some sort of protected activity, whether it's objecting to, refusing to participate in it, or outright reporting it to your supervisors. And then there was an adverse employment action taken against you. So retaliation of some sort, look, sometimes they defame this person and say like this person, and they don't fire them. They force them to quit kind of thing, right? They demote them. So it's an adverse employment action is taken against you. And then the hard part for us as lawyers at the end is proving the causal connection. So there has to be a causal connection, or in layman's terms, like, it has to be a cause and effect. So if you were a crappy employee and you were already on all sorts of performance improvement plans, and then you show up and say, hey, I'm a whistleblower now, and then they fire you, it's going to be tough, right? Because they're going to say, well, wait a second, we were kind of in the process of firing this person already, and they kind of, did their last, right. And then if the flip side is, let's say you report something and they say, oh, okay, we'll fix it. We won't do that. We don't want you to do that. And then a year and a half later, they fire you. That's also tough to establish, right? Because now there's not like this, it's called temporal proximity. So like there's a short period of time between when you became a whistleblower, when you said something, and when they took its adverse employment action.
It also probably has to be relevant to whatever you're whistleblowing. If you're whistleblowing something and the claim is false, right, that they weren't doing anything wrong, there probably takes time to figure that out. And then, so what does that timeline look like for somebody? So
most of the cases that I've seen that are actually good, viable cases are, an employee will report something that let's talk about reasonable belief real quick, right? So New Jersey, another thing that makes New Jersey's law so powerful is this concept called reasonable belief, right? You don't have to prove that this activity was illegal, okay, or unlawful. You don't have to prove that as an employee. The New Jersey, what it does is it basically puts a normal person into your shoes, anybody else, right? Like the common man into your shoes, and says, would the common man or woman believe that this is unlawful? So it's a reasonable belief that something is unlawful. Right. So I think this is illegal. And then I go and I say to my boss, hey, I think this is illegal. I don't think we should be doing this. Even if I'm wrong about it being illegal, if my belief was reasonable, you still have that
That's
hook.
a pretty wide open door. It's funny. It makes me think of those, the used car and the car radio ads where they're just like, these deals are unbelievable. They're almost illegal. And then it's like, well, I mean, reasonably, they said it was illegal to sell these cars for this low. It must be illegal. That's
Right.
reasonable belief. So New Jersey car
Careful,
dealerships,
right,
careful
yeah,
with your
careful,
ads. Yeah,
right.
that sounds, I mean, that's, well, so, okay. So if you reasonably could believe, but again, this all comes back to retaliation. So if you reasonably believe that there was something unlawful going on, you whistleblow it, and your boss goes, okay, well, this isn't illegal, and look, it's fine, go back to work. Nothing happened. But if you whistleblow because you reasonably believe something was illegal that wasn't, and they retaliate, this is what we're protecting against. We're
Right.
protecting against that act of retaliation
Exactly.
for coming forward.
Right.
Okay.
Exactly.
Is there any sort of nuance in terms of how you come forward, right? Because if you come forward and you just go, hey, I'm kind of concerned, can you explain this to me? Versus you guys are criminals. You're right. Is there some sort of acknowledgement of how that is being processed as well?
Well, look, you gotta use your own kind of best judgment, right?
Okay.
If you and it also depends on how big of a company it is, right? So the bigger the companies are, they're usually going to have policies and procedures and employee handbooks, and they're going to have a whole process of how they want you to be a whistleblower, right? And so if you're an employee and you work for a big company, there's usually a process. You should look into that process before you do it, right? They usually give you a channel of a person that you would contact that maybe isn't even your direct supervisor,
Yep.
but is somebody in HR that should be neutral and that should be kind of, disconnected from the actual activity, right? And so, for a larger company, yeah, but what we see a lot is, small businesses, and you work for a company that's got 10 employees, you directly report to the CEO, right?
Right.
And you're like to the CEO, like, hey, I don't think we should be billing for these. I don't think we should be billing the federal government for these services that we didn't perform, right? And they're like, oh, okay, well, you're not in charge of billing anymore.
Sounds
right.
a little retaliatory.
And and then the other piece of it, to your question about how you should report it, you also shouldn't come and be like, hey, you're a crook, you're billing in illegally, and then you throw your shirt on the ground and storm out of the place.
Right.
That's well, you just quit, I think, right? So we didn't retaliate against you.
Right. You retaliated against yourself, it seems like. Okay, that's really so the big piece I think that's really important is, and obviously the spirit of the law is so that whistleblowers feel comfortable to come forward. They feel safe. That if I'm going to come forward, I'm going to talk to my boss, it's going to ultimately help businesses do the right thing. And businesses should know, hey, you can't retaliate against this person for trying to do the right thing. But the whole, I hate to use the term, and the whole ambulance chasing element of things and those concerns of like, oh, I'm whistleblowing, I hope to get something. You don't have a claim unless
you get retaliated.
Unless you get retaliated against.
Right.
I think that's an important, okay. That's
and
an important
I think you should
distinction.
really, putting my lawyer hat on, and I tell people that call us about this all the time, if you're even thinking about whistleblowing about something, it might be the time to talk to a lawyer then, because you really do want like a roadmap, and you don't want to be kind of thinking about, in hindsight, I should have done this or I should have done that. We tell people that if you're gonna object to some sort of conduct that is unlawful, especially in a small business setting where it's not like, okay, you have to go to HR and it's this completely different, separate setting. But if you're gonna whistleblow in a smaller business, you really do want to document it contemporaneously, right? So even to the extent that you send an email to your boss, and as soon as you send that email to your boss, you forward just that one email to yourself to say, hey, I sent this email on, December 3rd, 2025, and then I forwarded it to myself on December 3rd, 2025. So there's no question about did we send it or not.
Right. Because you could be potentially, and not to get in the legal space, but you could potentially have handbook procedures that you should not be sending outside emails to personal emails and things like that, right? So you have to be very conscientious about how you're doing that, why you're doing that. You're coming to the point of the conversation that I wanted to get to is the when. And I'll challenge you with a difficult question, I think, as an attorney, is if I'm about to whistleblow at a small business, right? I recognize that obviously anytime you're going to do anything, it makes sense to talk to an attorney. But the thing we also talk about is return on investment. I also, let's say, don't think my employer is going to retaliate against me, right? Like, I don't think that's I don't think people are walking around assuming that, right? Usually. So, there's a cost, of course, to have an attorney build you the roadmap and consult with you and tell you. So I guess my question to you is, if I'm about to consider whistleblowing, I think that there's this concern. I'm going to go to, so now I've got to spend money to talk to an attorney to build a roadmap. What's the when and what's the...
So most CEPA type of claims are employment claims, and we take those on contingency. So the consultation there would be free. It wouldn't cost you anything out of pocket to talk to us, to say, hey, I think this might be unlawful. What can I do about this? So that's why we do kind of push people to try to reach out to us before they report.
Right. Well, then that makes total sense. Is that you're even if you're assuming best intention, and I love that you said that, because even if you're assuming best intention, hey, I've got a great relationship with my boss, this shouldn't be a problem, but I am a little bit concerned about this thing that we're doing. Take a moment to go, okay, what if which is what all contracts are for, right? We wouldn't need contracts if everybody just did what they were supposed to do and always work things out. Sometimes people don't. And so if you're going to take the step and go talk to somebody, talk to an attorney first. Hey, what's my roadmap? What should I do just to protect myself in the event that this does get,
absolutely
into retaliation?
I really think that that's something that you should be thinking about early in one of these cases, and that's why I wanted to talk about it today.
Yeah.
The other thing that you said that I wanted to touch on, I think was a really good kind of question. You didn't see, but you thought it, but you didn't ask it. So I'm going to ask it for you.
Oh.
So
do I have to answer it?
Yes.
Okay.
So you said, some employment policies might say you can't send outside emails to yourself. Right?
Oh, right.
So the question that I get all the time is like, hey, I work for a company with like sensitive information. I probably shouldn't be forwarding it to myself. Can I be fired for even forwarding that email?
Yep.
And there's actually really interesting law on that in New Jersey. There's a reasonableness standard. Again, reasonable. Everything's reasonable, right? And so, did you need this limited information to establish your case or to prove your case, right? So if you think about, two different ends of a spectrum, end of the spectrum number one is you forwarded yourself the 4 emails, and then you forwarded yourself the 2 emails where you went back and forth with your employer notifying them that it was your unlawful. You forwarded yourself those 6 emails as proof in case they retaliate against you and fire you.
Yep.
That's this end of the spectrum. And then this end of the spectrum is my employer is doing everything unlawful. I downloaded their entire hard drive onto this USB, right? The question is, there's a reasonableness somewhere in between. Did you, in some businesses, maybe you do need to download data to show that you're billing for services that weren't performed.
Right.
Otherwise, how am I going to prove it if my employer deletes it later or I can't find it later, right? And I might have to forward myself an email where my boss asked me to do something that I think is unlawful in order to show that that's what I think it was. That's this end of the spectrum. And if you do that, you're typically protected and it's typically reasonable.
So that brings up an interesting question to me is, what if I'm involved?
Well, a lot of times people are involved, right? And a lot of times people are involved and they don't realize that they're involved until like some portion of time goes by, right? I just saw something like this in a completely different case, but this person was in charge of dealing with this one supplier, right? And they've been dealing with this supplier forever. And at some point when some regulations changed, they were like, oh, we don't want you dealing with that supplier anymore. And this person went like, well, why wouldn't I be dealing with the supplier anymore? Turns out that the way that they were dealing with the supplier was less than lawful, right? And so they kind of, I don't know if this person's necessarily a whistleblower in this case, because they just kind of like took this person off of the, off of this account, right? Off this account. And then, but if this person got taken off this account and said, wait a second, I think what you guys are doing with that account is completely illegal, completely unlawful, and then they retaliated against her,
then it would fall under CEPA.
Then it would fall again under CEPA.
Okay. And so if you're involved in a situation, and I was kind of getting into the place of like, what if and then you change your mind over time, right? And
well, listen, the government kind of still wants you to
do the right thing.
Do the right thing, right? And I want to distinguish, there's this concept called qui tam, which is where you're bringing a claim on behalf of the government. And we're not talking about that today.
Okay.
It's a whole different area of the
Save
law.
it for another episode.
It's very complicated. We actually don't try to do those cases because those cases are super complicated.
Okay.
You're basically bringing a case on behalf of the government and then asking the government to take it over from you. Right? So now you're saying the government's being defrauded. I know. I'm going to sue on behalf of the government, and we want the government to come take it over.
I have so many questions, but we're not talking about today. Save for another episode.
And I'm not an expert at it, so I don't want to go outside.
But it's an interesting space.
It's a very interesting space. But what we're talking about here is much more nuanced, right?
Yeah.
You're an employee.
Yep.
You work on something that either somebody's asking you to do something illegal or somebody's asking you to do something that you believe is illegal. And you either say, I don't think we should be doing this, or I don't want to do it, or hey, I think this is illegal, and then you get retaliated against. They demote you, they lower your pay, they take away your commissions, or they outright fire you. Then you really have some claims, and I want to talk about kind of number one, what types of stuff is like illegal versus not illegal.
Yeah, I think that's important.
And then number two, what claims do you have, and why is CEPA so powerful?
Okay, let's do it.
Where do you want to start?
So let's hit the illegal versus legal. What are the things that either you see, let's hit the list, right, of areas where you could whistleblow.
Okay. So there's, again, we'll go spectrum, right? On one hand of the spectrum is like, we tried to do a case like this years ago and it kind of blew up in our face. It was basically like a therapy practice, a physical therapy practice. And they were saying that too many people were being scheduled into this therapy practice, and because too many people were being scheduled, the one-on-one time that the therapists were supposed to have wasn't really being had.
Okay.
And so that was so kind of like, employment practices versus illegal. And it was so hard to establish that this would be a reasonable belief that this is illegal.
Right.
That makes it like really, really hard to say this is an illegal,
because there's no defined you must have PT for this amount of time for these types of injuries, and if not, you didn't meet the criteria.
Exactly.
But there's I assume insurance implications and things like
there's
that. So
potentially insurance implications, right? And so this is where it gets to kind of illegal, right? So if you're the other end of that spectrum, and I've said this a minute ago, is if let's say we were in that therapy practice, we're using them as an example, and Bob comes to that therapy practice twice a week, but you're billing as if he came 3 times a week,
right.
And then you're having him sign a piece of paper that he came that 3rd time, right? Like that's illegal,
right?
You're probably engaging in some sort of fraud against some sort of entity, right? The in between stuff will typically be, is there some sort of thing or statute or regulation or law that says you can't do this, right?
Yep.
Like, can I give somebody money in exchange for getting preferential treatment somewhere? I don't know, maybe, right? If you do it in a certain way, and then that goes back to this reasonable belief, right? Because this is why New Jersey is so strong. All your belief has to be is like, hey, I don't think you could do this. I don't think it's right that you should be able to do this. You don't necessarily have to go in and say you're in violation of,
code number.
Exactly.
Right.
Exactly. You don't have to do that.
Okay.
And so, but that's another reason to call a lawyer ahead, because if you start whistleblowing on stuff that's not like objectively not really a problem,
right,
you really risk your job. You risk the retaliation. They retaliate against you, but then they find out that your belief wasn't reasonable. Now you're out of a job. And I think that the reason that New Jersey does this and makes it so open-ended that you can get into it is because, look, to put myself into the employee's shoes, right? Let's just say you have a nice job where you're making a lot of money, right? $250,000 a year. It's like a fortune to a lot of people, right? And you're seeing this illegal thing happening. You realize that if you report this, there is a good chance that you're going to lose your job.
Right.
Like a very strong chance, especially in a smaller company where the boss could just be like, I don't need this guy anymore.
Right.
Right. And so, and that goes into the damages aspect of it too, by the way, is, it is a scary thing to do if you have a comfortable job, or, you've been there for 15 years and you don't know how easily you could find another job making the same amount of money. It really makes it very hard for people to come forward.
So let me ask you that. What's the cost benefit analysis, right? Aside from morality and just doing the right thing, right? If you're in this really nice job, you're happy to be there, and you're sitting there and doing this analysis. Should I come forward? Should I not? Because there's an awkwardness, right? Like if you come to your boss and you go, "Hey, I don't think we're doing this correctly," right? And they may or may not be doing that correct. No, now you still have to work. You still have to go in there every day. There's even just forget the financial part. There's a personal and emotional aspect that every day now you got to walk in and feel like I'm the resident narc. Like I'm the guy, I do think that one thing that shifts it, and as I'm hearing you talk and we're talking about claims and you're a lawyer and all this different thing, I do think that the one thing to remind everybody is that if you're working in a place that generally people are trying to do good, or you have a good relationship with your boss, like this can still be scary, it still be concerning. But again, you're not immediately in the whistleblower context going to the state of New Jersey and going, "Hey, I think this is happening." You're going to your boss, you're going to a direct report, and you're saying, "Hey, I think we should vet this." And I think that if you're working in a good place, they're going to just do the right thing and say, "Oh, that's a mistake. I think you're wrong. You can vet it," right? So I think that's the one area to calm it down a little bit in this conversation, because I think that, again, it's about the retaliation, which may happen, and we should protect ourselves against that, but it shouldn't necessarily prohibit you from coming forward if you're in the right place.
Yeah, and I think that's true. And unfortunately, we kind of see, the instances where it's not right. Because if you go and say, "Hey, I don't think this is okay," and they're like, "Oh, you're right, this isn't okay, we're fixing it," you're never going to call us.
You're not getting the call, right?
Right. Exactly. You're never going to call us. And so what we see is the people that, say this is the wrong thing. And what winds up happening is, the boss will immediately alienate that employee.
Right.
And so they will, they'll potentially defame them to the other employees and say, "Susie's such a problem. She can't work here anymore." She's, or they'll harass you and kind of retaliate against you in another way to try to get you to quit. Right. Like, "Oh, well, maybe we could just be mean to this person and they're just going to leave on their own." Right. And so there is this kind of becoming a pariah.
Yep.
If you go and become the whistleblower. And so
let me go to the other side for a second. I'm that $250,000 a year person that's happy in their role and whatever. And I turn around and I go, what is the consequence of not coming forward? Like what happens when because there's another element of this, right? You're protected in CEPA, but if I don't come forward and the organization gets in trouble, right? I'm not the owner. It's not my company.
Well, you're also going to be out of that job, right?
So, but to play devil's advocate, I might be out of the job anyway, because I could get retaliation. I got to go to an attorney and I got to go through this whole headache, right? Which, hopefully because of CEPA, if I'm in New Jersey, I'm going to win anyway. But the other side of it is there, right? We talk about small business owners and businesses having LLCs and incorporating so that they can create separation between the personal and the business and they can protect themselves. Are the employees otherwise, and I feel bad even saying this because it's kind of like, well, maybe I don't need to whistleblow. Like, right. Listen to John. This is the devil. I'm the devil on the shoulder right now. Like, don't say anything, Susie. Everything's fine.
Right. Well,
so what's the consequence if I don't say something?
Well, so there's a couple things, right? Number one, if you're actively, like if you're the person doing the billing, the fraudulent billing, the government could be like, "You should have known better.
Susie."
Yeah. Susie, you knew better. You did the fraudulent billing and now we're going to go after you also.
Okay.
Right. I mean, it's possible. I don't know that they want to or do, but it's
possible.
Right.
Yeah.
And
you're as an employee maybe not protected under the same sort of incorporated because you're an employee there. You don't have your own corporation.
Well, you should be protected under the corporate structure. Have to think about that, but okay. I think that if the company goes bankrupt and they paid Susie a lot more money than they should have,
right?
They could go after Susie. Like, "Hey, Susie, you knew what you were doing was illegal." And like, typically billers get paid $50,000 a year. You were making $250,000. Like,
we know what's up.
We know what's up, right?
Got it.
So that's number one. And then number two, and I think I want to cover this before we finish this episode, is the incentive is very strong
Okay.
for the employee to come forward, and New Jersey does a great job at that. What they do is this is one of the most liberal. I don't mean liberal in like conservative liberal. I mean liberal as in like anything
The
can
law,
fit into
yeah.
it. Laws.
I believe you use the term a truck could drive through it.
Exactly. Yeah. And so number one, like let's say you get fired,
Okay.
right? And so you get fired today. We're in December of 2025. You have, first of all, we'll cover this in a second, but you have a year to bring the claim. Okay. So you can't sit on it. You can't be like, hey, they fired me 4 years ago. Now I'm ready to bring a CEPA claim. So you have a year to bring a claim. But let's just say that, let's say they fire you in December of 2025. By the time you meet with a lawyer, you put together your lawsuit, you file it, it's like March. So it's like been 4 months now, right? So number one is you'd get back pay. So for those 4 months that you should have been employed, you get the back pay. Number two is you potentially get not potentially, but you can ask for front pay.
Okay.
And you say, hey, I was senior in this position. I'm, 58 years old. I thought I was going to retire here at 65. I want 7 years of salary at this rate.
Wow.
Okay. So you can ask for it. You're not necessarily going to get it.
Right.
But you can ask for front pay. Okay. Then you get this concept of emotional distress damages, right? And you typically don't get emotional distress damages in like employment contexts and in any sort of contract context. But in this kind of context, because you can become the pariah and because you can have, the employer defaming you and disparaging you and harassing you and trying to get you to quit, you can really like, hey, I had to go see a therapist. I couldn't sleep at night. So you can get emotional distress damages, which can be unlimited. Right. Wow. Potentially. And then if a court thinks that their conduct was so egregious and it was so knowing and so purposeful, they could award punitive damages. So that could be another hammer. And then to add to all of those hammers that you get to make us lawyers incentivized to take these cases on contingency, if you win that case, you also get your attorney's fees. So the money that you've spent pursuing the case, you can actually recover.
Okay. Now, do the attorneys generally take a percentage as well in addition to that, or it's just the baseline?
It's all different for different law firms do this differently. New Jersey's actually got an interesting protective law. I would say this is a conservative law, where actually attorneys can't charge too much money. In a lot of other states, an attorney fee could be like, hey, we charge 50%. And if you go for it, you go for it, right? In New Jersey, there's actually limits on what the attorney can charge, and they don't want the attorney making too much money. And so like after a certain number threshold, the percentage that you get on the rest of the money goes down. So it's like the inverse of paying taxes.
Oh, interesting.
Right. Okay. So if you recover $1 million, if you recover $1 million, exactly. And so, and what we do on our firm is we actually lump in like whatever we would recover for you, including the attorney's fees, we lump it all in together, and then we take a percentage from that. So the damages and the recovery is actually potentially very high. Fascinating.
So I think we've got a pretty good summary here of what the legislative landscape is in New Jersey to protect whistleblowers, the opportunities to come forward, why you should come forward, and the protections that are there. Is there anything else people should know and that they should talk to an attorney? At the beginning of the process to make sure that they're following the best protocol to protect themselves. Is there anything they should know?
Two things. I can think of two really important things. Number one, statute of limitations. Okay. You got to bang your fist on the table. Statute of limitations is the amount of time that you have to file this lawsuit. I can't tell you how many calls we get from people that are either just beyond, it's been more than a year, so you're beat. Sorry. Right. Or they're so close to the statute of limitations that we as attorneys don't want to get involved.
Because by the time you file everything.
By the time I get my head wrapped around it, by the time we review everything, we're so close that we have to file it, and we're not sure that we want to file it yet. So you really want to be very early in the stages talking to an attorney. So, ideally you come before you even whistleblow, but if you've already been whistleblown and they've already started to retaliate against you, it's imperative that you see an attorney as fast as possible. That's thing number one.
Yep.
thing number 2, and this is an important one that we might want to spend a minute on, is if you're bringing a CEPA claim, it really precludes all of the other claims, right? And so what winds up happening a lot of times is people say, well, I was discriminated against because of my age, I was discriminated against because of my race, and they discriminated against me because I whistleblew. Okay? It can't be all 3. Which one is it?
Okay.
Right? So if they fired you in retaliation for your whistleblowing, it's not the others, right? Because how could they have retaliated against you for your whistleblowing if they've fired you because you're old?
Right.
It can't be all of them. And so a lot of times what lawyers will do is they'll actually put all of the claims in the complaint, like in the alternative, right? So it's CEPA first, but in the alternative, it's age discrimination.
Okay.
Right? But by the time you get to the lawsuit, you got to pick one. But if you're in a point where you're whistleblowing and you're writing letters to your lawyer that they're discriminating against you because of your age, they're discriminating against you because of your race, and they're retaliating against you for whistleblowing, that email could essentially backfire on you. And that's another reason why you want to come to a lawyer early.
So just even you talking internally with your own attorney, saying that you suspect these things could backfire?
No. Internally with your own attorney is protected. Don't worry about that. I'm talking about if the whistleblowing letter that you send to your boss is like, hey, we were doing this illegally. I told you about it. And now I think you're retaliating against me. Either because of that or because I'm old and I suck at computers or something. I don't know. I'm making it up.
Right.
And you put that in your email to your boss. They're going to be holding that up email in court and saying, well, was it because I'm old or is it because I'm whistleblowing? Because it can't be both.
Interesting. So again, it just comes down to the nuance of talking to an attorney in terms of how you're framing all of these things. And really before you whistleblow, it sounds like, talk to the attorney so that you frame things correctly. I assume, just not to be, I'll intentionally be kind of gross about how I'm going to say this and then you clean it up. But like, is it just pick the one that makes the most money? Like if age discrimination is going to make the most money, we go on that and we have good evidence, we go on that? Or is because CEPA is so protective and strong, is that you listed all the benefits or the potential claims I could make and the potential rewards I could get? Is that the way to go? Do we have an answer? Like, hey, if you think that there is a CEPA case, don't worry about the other stuff. This is the one you want to pursue. Or is it not? Is it more nuanced than that?
That's actually a good way to put it. And I think that's another reason why you want to talk to an attorney early, because we started to talk about the key tam stuff, right? And key tam, what's interesting about key tam without spending too much time on it is if the government actually takes that claim and pursues it, you get a percentage of the government's recovery. And the government, Honey Badger don't care, right? So the government comes in and they go, you guys did 50 million in fraud. We want that 50 million back. Now you as a whistleblower get a percentage of that. So that's a huge claim, right? Potentially versus your employment claim, which is not worth all the money that they improperly defrauded the government of, right?
So always, it depends.
You want to talk to a lawyer up front because I might say to you like, hey, look, this might be a really good CEPA claim, but what you should do is go talk to the, DA's office. Right. Or you come to me and you say, hey, I think this is a CEPA claim. And I say, it's a weak CEPA claim, but it does look like they're retaliating against you because you're old. Again, and I'm sorry for saying it that,
No. But
New Jersey, actually, little tidbit about New Jersey. I don't know. Again, one of the only states very liberal about their age discrimination. In New Jersey, unlike in most other states, you could be discriminated against because you're too old or too young.
Oh, interesting.
Other states, it's usually because you're over 40. The Age Discrimination Act is because you're over 40. But in New Jersey, you could actually be discriminated against because you're too young to be doing this thing.
We should definitely do a different episode on that. I think that would be really interesting too, to hit the different ages and understand like what discrimination looks like in those cases and how it presents.
We'll bring Aubrey back. She's our employment.
That's her specialty. Anton, thank you so much. I think this was super valuable. And I think we'll have to, in another episode, hit for employers what they need to understand when it comes to CEPA. Yeah, and I look, we represent employers all the time, and we represent companies, and we try to help them with best practices and how to avoid these claims. So we'll definitely do another episode about how to avoid these claims and what to do if you're in employer shoes and an employee maybe comes and whistleblows.